Hey, good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this morning for what we call an arraignment. And what the arraignment is just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning the case. Now, the case that you have in this court is a criminal case. It's a misdemeanor criminal case. Criminal cases are divided into felony and misdemeanor. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they're convicted of the case. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to maximum 2 years in state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to maximum 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to maximum 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you don't have to worry about those type of punishments because, as I mentioned to you earlier, your case is a misdemeanor case. Misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the class A misdemeanor, the class B misdemeanor, and the class C misdemeanor. Now, if a person is convicted of a class C misdemeanor, the range of punishment is by fine only. The fine cannot be above or cannot exceed $500. Now, if a person failed to pay the fine, or if the fine was converted to community service, they failed to perform the community service, then the court can issue what is called a capias pro fine. That's just a warrant for you to either pay the fine or sit the fine out in jail. Now, if you sit the fine out in jail, you'll receive $100 credit that will go toward your fine and court costs, $100 for every 1 day that you sit in jail. So if you sit in jail 2 days, that's $200 credit that goes toward the fine and court costs. Okay, now the next highest misdemeanor is a class B misdemeanor. With the class B misdemeanor, the range of punishment is minimum 0 days to maximum of 180 days, which is 6 months in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. The highest misdemeanor is a class A misdemeanor. The class A misdemeanor range of punishment is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or you could be given a fine that does not exceed $4,000. Or you could be given both such jail time and a fine. Now, everyone here should have a clipboard. Who does not have a clipboard? Everyone, you don't have one? Are there any back there? Okay. Thank you. Okay. Now, I'm going to go over the paperwork with you. I mentioned to you earlier that one of the reasons why you're here today is so that the court can tell you about the rights that you have. Now, one of the rights that you have is the right to have an attorney. The clipboard have that information on it. I'm gonna go over that clipboard with you. The first document you should see on the clipboard should be titled Judge's Explanation of Rights to Defendants Without Attorney. All right, and that document looks like this. And I will constantly refer back and forth to this document. Okay. Now, it states that as a defendant in a criminal case, you have three options. Three options regarding the right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you may represent yourself. That is, you may waive or give up your right to have an attorney represent yourself. Now, under number three, the first one sentence paragraph states that if you want an attorney, you have enough money to hire an attorney, then your case will be reset. Reset means that you'll be given another court date to give you time to hire an attorney. The next one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But before you do that, you have to first fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, this is only for people who will be applying for a court-appointed attorney. So if you're not applying for a court-appointed attorney, you don't have to listen to what I'm getting ready to say. If you're applying for a court-appointed attorney, then you would have to fill out this document that is titled Jefferson County Affidavit of Injuries or Affidavit of Injuries. Now, you will have to fill out the first page, the entire first page, and then you will go to the second page, and on the second page, you will fill out the top portion that is titled Defendant's Oath, and then you'll fill out the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. All right. Now, going back to this first document, judge's explanation, the next one sentence paragraph is for individuals who will be representing themselves. That is, you have a right to represent yourself. In essence, you'll be waiving or giving up your right to have an attorney represent you. You'll be representing yourself. Now, if you represent yourself, you will have an opportunity to talk to one of the two prosecutors or assistant criminal district attorneys that's in court today. And the reason why you'll be able to do that is because one, just like your lawyer would have an opportunity to talk to them to see if they can work out something on your case, because you are representing yourself, you are your own lawyer. So you'll be able to talk to them about representing, about trying to work out something on your case. But before you're able to do that, this one sentence paragraph states that you may not speak to the prosecutor about your case unless you first sign a waiver of your right to be represented by an attorney. Now, the waiver is this document that is titled Waiver of Counsel for Purposes of Entering Guilty Plea Proceedings. That is also on the clipboard. Now, this is only for people who will be representing themselves. So if you're not representing yourself, you don't have to worry about this document. You don't have to worry about what I'm getting ready to say. Now, if you're representing yourself, you will sign this document. You'll read it and sign it. Now, for individuals who represent themselves, there's a paragraph in block form, the next paragraph, below the third one sentence paragraph. It states that you should be aware that the advantages and disadvantages of self-representation. Waiving your right to an attorney, representing yourself, may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you choose to represent yourself, this last one sentence paragraph states that you may change your mind at any time, okay? And ask that an attorney be appointed to represent you. Or if you want to hire an attorney, you can do that as well. Now, for example, what this basically means is that you represent yourself. Let's say you talk to the state And, you decided that, you know, you can't work out anything. And you say, well, Judge, you know, I changed my mind. I would like to hire an attorney. I would like to see, I qualify for a court-appointed attorney. You can. Now, you also have a right, before we go any further, I'll get back to that later on. But, at the bottom of this document, everybody's gonna make a choice. In bold letters, it says defendant's choice. Mark your initials next to, you're gonna mark your initials on one line, one of these 5 lines. And it says, if you would like to hire your own attorney, then you place your initials on the first line to the left. You sign the bottom of this document where it says defendant, you'll date it today's date, June 2nd, 2026, and then you'll stop. And this is the only document that you would have to sign. All right. If you have already hired an attorney to represent you, then you'll place your initials on the second line at the bottom of this document and the name of the attorney on the line to the right. And then you sign where it says defendant date, put the day's date, which is June 2nd, 2026. And this is the only form that you'll sign, and then you'll stop. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. You will go to the document that is titled Jefferson County Affidavit Issue, fill out the first page. And then you'll go to the second page, fill out the top portion that says defendant's oath and unsworn declaration by defendant, and then you'll stop. And if you've already been appointed a court-appointed attorney in your case, then you'll place your initials on the fourth line to the left, the name of the attorney on the line to the right, and then you'll stop, and this is the only form that you would have to sign. If you would like to represent yourself, then you'll place your initials on the fifth line, which is the last line to the left. You'll sign where it says defendant, you will date it, today's date, and then you will read and sign the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Okay. Do you have any questions? Before we go, yes. 2nd of June. Anybody else? Okay, all right. Now, we're gonna give you time to fill out the paperwork. Yes.
I don't have the.
Oh, you don't have a clipboard? Oh. Okay, we're gonna give you time to fill out that paperwork. Now, before I go any further, I need to inform you that you have a right to enter one of 3 types of pleas. Okay, you can enter a plea of not guilty. If you enter a plea of not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of guilty. If you enter a plea of guilty, you're telling the court that you committed the offense that you have been charged with. Or you can enter a plea of no contest. If you enter a plea of no contest, you're telling the court that you will not be fighting or you will not be contesting the charges. Okay? Now, the other right that I need to go over, which is this. You have a right to have a trial. You have a right to have a trial by jury. In the area over there, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors. Now, there's 12 shares, but because we're a county court, we only have a 6-person jury. District court has a 12-person jury. We're not district court. Now, 6 citizens from Jefferson County will be selected to serve as jurors in your case. And they can, well, what they'll do, they'll listen to all of the evidence that's presented by the state. and the defense, they'll listen to the arguments of the state and the defense. And then they will go back into the jury room to deliberate. When they come back out, they can either find you not guilty or guilty. You can waive or give up your right to have a jury trial. What that means is you would not be having a trial by jury. You still can have a trial, but it'll be what we call a bench trial. It's a trial by judge. The reason why they call it a bench trial is because the judge sits on the bench. And so you have a right to have a bench trial. And what the judge will do, the judge will listen to the evidence that's presented by the state and by the defense. Judge will listen to the arguments of the state and the defense, and then the judge will apply the facts of the law and decide whether or not to find you not guilty or guilty. And you can waive your right to have a trial by judge too. Now, if you waive your right to have a trial by jury, trial by judge, you indicating to the court that you enter a plea. So you either enter a plea of guilty or no contest. Now, you'll have an opportunity, or you or your attorney will have an opportunity to talk to the prosecutor to see if you can work out a plea bargain. Now, if you are able to work out a plea bargain, then what that means is you and the state has come to an agreement. Now, I need to mention to you, I mentioned to you earlier that I talked about the range of punishment for Class A, Class B, and a Class C misdemeanor. What I failed to mention was that you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation. Unadjudicated probation. And with that type of probation, what that means is you will not have a conviction on your record. And if you successfully complete the probation, the case will be dismissed. It will not result in a conviction on your record, and you may qualify for a non-disclosure. And what a non-disclosure is where your record is sealed to the general public. Operative word that I use is general public. For example, let's say you applied to a job at ExxonMobil, which is part of the general public, and they did a background check. You had a non-disclosure. Guess what? Your record is sealed to them. They can't see the fact that you placed on unadjudicated probation, and because it's sealed. Now, I said general public. Now, there are certain governmental agencies that are listed in the Texas Code of Criminal Procedure that can't have access, like the police department, for example. Okay. Now, the other type of probation, I said is unadjudicated probation. The other type of probation is called adjudicated probation. You have unadjudicated probation and adjudicated probation. Adjudicated probation is normally referred to as regular probation. It does result in a conviction in record. However, there's something that is called judicial clemency, whereby the court can give you, can set aside your conviction. It's almost like giving you a pardon. Similar to that, it's not the same. And so you will no longer have a conviction on your record. However, if you get another case, we say a subsequent conviction later on, then the case that you receive judicial clemency on can be resurrected, it can be brought back up, and it could be used against you. And if you try to get a license with, say, Child Protective Services, they can deny giving you a license, or if you have a license, they can revoke and suspend your license with Child Protective Services. All right. Now, let's say, okay, now the next thing I need to talk about is you have a right to call witnesses to come to court. Okay? They sit in that chair that has the microphone in front of it. We call that the witness stand. They can testify for you or against you. If you have a lawyer, your lawyer can ask the questions. If you're representing yourself, you can ask the questions. We either call it direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. Now, what that means is, means that you will not be calling witnesses. it does not mean that the state will not be calling witnesses, because the state will be calling witnesses in your case. Now, you also have what is called a Fifth Amendment right against self-incrimination. We always say it's your right to remain silent. Some people say, I take the fifth. A lot of times we watch a television show, Law and Order. Television lawyer, you go walk up to the witness stand and ask a question. First, I take the fifth. That means I'm not saying nothing. You can't make me say nothing, because I'm exercising my Fifth Amendment right against self-incrimination. All right. Now, if you think about it, it makes sense. And the reason why I say it makes sense is because of this. The state has the burden of proof. What that means is they have the burden to prove that you're guilty beyond a reasonable doubt. Okay? You don't have to prove yourself guilty, right? You don't have to prove that you did it. You don't have to say nothing. That's their job. So that's why it makes sense. So you have a right to remain silent. Now, you can waive or give up that right. If you waive or give up that right, that simply means that you will be taking a witness stand. Okay? But you can't be forced to take the witness stand, is what I'm telling you, if you do not desire to testify in your case. All right. Now, the next right that you have a right to have what we call discovery. And what discovery is, it's a right to have access to the state's file that the state has on you. In essence, you have a right to see the evidence. In essence, you have a right to have access to the evidence. You have a right to see witness statements, your statements, police reports, lab reports. You have a right to see photos, video recordings, a right to listen to audio recordings. You have a right to see documents and instruments, or whatever the evidence that they have that they'll be using against you. You have a right to have access to that, so you can prepare for trial. Okay, or see what evidence they have. Now, you also have a right to waive or give up your right to have discovery. By waiving or giving up your right to have discovery, that means that you will not be having access to that information. Now, everyone that's here today, you have charges filed against you. You've been arrested, placed in the county jail, you bonded out of jail, you get out of jail on a cash bond, which means that you pay the full amount of the bond to get out of jail. You get out of jail on a surety bond, which means you pay a bondsman a percentage of the bond to get out of jail, or you're out of jail on what is called a PR bond or a personal recognizance bond, which means that you did not have to pay anybody to get out of jail. You was just released under your own personal recognizance. I say that to say this. Every day that you spend in jail can be used as credit towards your punishment. So, for example, now the operative word is every day. I'll explain that to you. Let's say you were booked in the jail at 11:59 p.m. last night. And then you booked out of jail 2 minutes later at 12:01. Guess what? You was in jail 2 minutes, but that's 2 days. Why? Because one day was Monday and the next day was Tuesday. So you get credit for 2 days. You don't have to be there 48 hours. All right. And so I say that to say this. Every day that you spent in jail, can be used as credit toward your punishment. So let's say you spent 5 days in jail. Let's say you or your attorney talked to the prosecutor, they offer you 5 days in jail. That simply means you don't have to serve no more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you've already served. Now, if they're offered 7 days in jail, you serve 5 days in jail. That means you only have to serve 2 days in jail because you have 5 days credit. You subtract 5 from 7, at least 2. Now, every day that you spend in jail, also you receive $100 that will go toward your fine and court costs. So if you spend 5 days in jail, that's $500 that can be used towards your fine and court costs. So if they're offering you a fine and court costs of $500, that simply means you don't have to pay anything. Why? Because the time that you spent in jail has already paid it off. Therefore, it will be taxed every time. Now, if they're offering fine and court costs of $700, that means you only have to pay $200. Why? We will subtract 500 from the 700, that leaves to 200. you'll be required to pay the $200 on the day that the case is taken care of. If you cannot pay it, no problem. Why? Because we could put you on a payment plan where you pay it off in small monthly installments. But let's say, even if we put you on a payment plan, you will not be able to pay it, no problem. Why? Because we can convert the fine and court costs to community service. So for every 1 hour of community service that you perform at a nonprofit organization, $12.50 will go toward payment of your fine and court costs. So if you work 8 hours, 1 day of community service, that's $100 that you've earned that will go toward your payment of your fine and court costs. So in our scenario, you work 2 8-hour days, you paid off the $200 fine and court costs. Okay, now, if you haven't been in trouble before, you haven't had cases filed on you before, if you the first time had one or more cases, Jefferson County has a program whereby they will dismiss your case. Okay? And you can get it wiped off your record, like it never happened. The Jefferson County DA's office has a program that is called pretrial diversion. That's for individuals who, one, this first time getting in trouble with one or more cases, they can, if you get in the program, well, first of all, in order to get in the program, 3 things has to happen. 1, that's to be your first time getting one or more cases, first time. 2, you have to have a lawyer to help you, assist you with the application process. The lawyer could be appointed, can't afford it, no problem. You can ask, your court-appointed attorney can submit the application for you. Or you can hire an attorney, don't matter. The other thing is, it cannot be a case involving unlawful carrying a weapon or resisting arrest. For all other cases, DWI, assault, etc. All other cases you can qualify. Now, again, if you get into the program and complete the program, you dismiss the case. And once the case is dismissed, you can get what is called an expunction, which means erased, deleted, wiped off your record like it never happened. Somebody go and see you, you have a expunction, somebody go and search your criminal record, guess what? It's blank. It's gonna be blank because they deleted, okay, taking it out. Yes.
What if I had an unlawful carry and like the drugs in my name? I still can't do it.
No, the case can't be an unlawful carrying a weapon or resisting arrest. It can't, can't be one of those type cases. Okay, the other thing is, the district attorneys has another program that is for veterans. It's called Veterans Court. If you're a veteran of any one of the branches of the United States military, they have a case, but they have a program similar to, it's part of the pretrial diversion program, but it's similar to the previous program that I mentioned, that is for veterans only. You could be a veteran of any one of the branches of the United States military, you get into the program, complete the program, they dismiss the case, and you could get it expunged from the program. Okay. This court, County Court at Law number 2 of Jefferson County, Texas, has a program that God led me to start within the first 100 days of taking office in March of 2017. The program is called the Community Safety Initiative, or the CSI program, which is the acronym that stands for Community Safety Initiative. In that program, we have partnerships with various agencies in our region, or in Jefferson County region. And the program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so what we do to prevent that from happening, God led me to start this program that's called the CSI program. Now, Spindletop normally is here on Tuesday and not here this morning, unless they're next door in one of the other courts. But Spindletop, what they'll do, first of all, Spinotop is our local mental health authority. They have the expertise to address mental health issues that individuals may have. Person may be mentally ill or maybe what you call, have like intellectual disabilities. And if they are, fitting in these categories, they have the ability to address your mental health issues. Now, you do not have to be incompetent or insane to participate in the program. You can merely suffer from anxiety or depression or any other mental health issue. And they have the expertise to address your mental health issues. Now, the first thing that they will do is conduct what we call an interview. The interview can be in our jury room, at their facility, by telephone or by text, whichever is convenient for you. They will also do an assessment to determine what the mental health issue is. And then they will develop a treatment plan to address your mental health issue. Now, they also have another program for individuals who may have problems with drugs or alcohol. They have a program that is called ATAR, A-T-A-R. ATAR is an acronym that stands for Addiction Treatment and Recovery. We also have a partnership with our local Drug and Alcohol Council that has a program that is called OSAR. It's an acronym OSAR that stands for Outreach, Screening, Assessment, and Referral. All of those programs are drug and alcohol recovery programs. And what they would do a screening, a interview, and then they develop, they would do a screening, which is the interview, and then they would do an assessment to determine what your issues are with drugs and alcohol, and then they would develop a treatment plan for either outpatient or inpatient treatment. If you are unemployed, or if you're looking for a better job, then we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. That is an acronym that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas that you select, then they will help you to get a job in the area that you're trained in. If you do not have a GED, or if you have not graduated from high school, then Spinotop, as well as the CICE program, has a program, has a GED program where you could receive your graduate credits to diploma now. All of these programs that I just mentioned are free. Does not cost you anything but time. And I like to say in this quote, we don't just give time, we take our time. And that simply means we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. If we produce productive people will not commit crimes. Why? Because they have too much to lose. So I like to say that when you come to County Court at Law number 2 in Jefferson County, Texas, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, then we'll make a difference in the community, because what comes out of the home goes in the community. And so if you're interested in any one of these programs that I just mentioned to you, just let us know. And we'll be happy to assist you and get it on the road to living your best life. So at this time, I need to mention to you that on those forms at the top it says state of Texas versus and have a blank. Please print your name on the line, because if your handwriting is like mine, sometimes I can't read. Okay, so just print the name so we'll know who, the application is for. Okay, now, again, if you need any help with your paperwork, we have our court personnel, including myself, who will be happy to assist you at filling the paperwork out. And we're going to pick that paperwork from you, and we're gonna put you into one of three categories. One category is you want to hire an attorney. If that's the case, your case will be reset. Reset means you'll be given another court date so that you can hire your attorney. That will be done today, and you'll be free to go. The next category, if you would like to apply for court-appointed attorney, then if you qualify, your attorney will be appointed today. And the third category, or third and final category, if you'd like to represent yourself, you'll have an opportunity to talk to one of the two prosecutors to see if you can work out something in your case. And if you can, then your case will be taken care of today. Now, again, we're still in court. Make sure you conduct yourself accordingly. If you need to use the restroom, there are two restrooms that's right outside in the hallway. There's the men's restroom in front of County Court Law number 3, which is right next door. And on the opposite side of the hall, in front of the 172nd District Court, there's the women's restroom. You'll be allowed to use the restrooms. Please do not leave the courthouse. If you leave the courthouse, and if your name is called, and you're not here when your name is called, guess what? Your bond is gonna be forfeited, a warrant will be issued for your arrest. You will be arrested, placed in a jail, the county jail. You're gonna have to bond out, and guess what? We're gonna have to go through this all over again. So we don't want to do that. We're gonna try to get you in and out as soon as possible. Okay, now, before I say anything again, make sure you conduct yourself accordingly. We're still in court. Do we have any questions? Anybody have any questions before we go into recess? Yes, ma'am.
You gonna work it on
Well, you gotta get your paperwork in. Okay, make sure your paperwork in, and we'll check it. We'll try to get you in as soon as Okay, we're gonna be in recess. Should we get all the paperwork done? Oh, she's over there. Jefferson County Court at Law number 2 is back in session. The court is in session with its arraignment docket. First case is cause number 26CCCR 0908. Case is filed in the state of Texas versus Erica Richards. Ms. Richards, is that your full name? Ms. Richards, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Richards, you may put your hand down. How are you doing, Ms. Richards? That's good. Now, Ms. Richards, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit Injuries. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Ms. Richards, before you sign and initial these documents, did you read the documents? Understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Richards, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you is Mark Faggart. Attorney Faggart will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please stand in front of the court coordinator.
Reba, Elizabeth Wright.
No, he's in here, but I can't hear him.
Ms. Wright, your full name is Reba Elizabeth Wright? Ms. Wright, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Wright, you may put your hand down. How are you doing, Ms. Wright? That's good. Now, Ms. Wright, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorneys. Recognize this document. Is this your signature online as titled defendant? And are these your initials online that state you would like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? And Ms. Wright, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Ms. Wright, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you will be free to go, and you have a blessed day.
Yes.
Please have a seat in that first chair on the wall. Thank you, ma'am. Thank you very much. Brandon. Oh. Is this Brandon LaFleur? Brandon LaFleur? Is that right? I don't think that's Brandon LaFleur. Oh, okay, he just, his signature, he's, okay. Where is he? That's the one with Mr. Okay, who else we have? Okay. Everybody turn in their paperwork? Okay, we still have double. Okay, Ms. Neville, the court is going to grant this motion to allow Mr. Wilkerson to withdraw the motion that you have agreed to. Now, at this time, Ms. Neville, you still want like the court to appoint you a lawyer? All right, so the next lawyer on the list is Attorney Todd LeBlanc. Okay? Attorney Todd LeBlanc will be given information to contact you. And you will also be given information to contact him. Our court coordinator is going to give you that information. Once she gives you that information, could you check and see if we have bond conditions in this case? I'm sure we do. Okay. Our court coordinator is going to give you your reset. Once you get your reset, you'll be free to go. Yeah. And you have a blessed day. Please have a seat in that second chair on the wall. You can give me another court date on the gentleman that's on Zoom. Oh, he lives here. Actually, probably 1 week.
It's the night.
June 9th, okay. Mr. Hunter, you can take your mic off of mute. Mr. Hunter, you can take your mic off of mute. Mr. Hunter, you can take your mic off of mute. Yeah, Mr. Hunter, you can take your mic off of mute.
Yes, sir.
Okay. Now, what's that court date again?
June 8th.
Okay, this case, Mr. Hunter, will be reset to June 8th,
Yes, sir.
2026 at 9 a.m. You need to be in court in person. That's next week.
Roger that.
Okay, you're free to go and you have a blessed day.
Yes, sir. You as well.
All right, bye. Christopher Lee Brandon. Mr. Brandon, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God.
Yes, sir.
Mr. Brandon, if you may put your hand down. How are you doing, Mr. Brandon?
So,
I'm doing fine, thanks for asking. Mr. Brandon, if I have before me two documents, the first document is judge's explanation of rights to defendants without attorney. You recognize this document?
yes, sir.
Is this your signature on the line as titled defendant?
Yes, sir.
Or these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that's titled affidavit of interest. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled defendant signature. Is this your signature?
Yes, sir.
Mr. Brandon, before you sign and initial these documents, did you read the documents?
I did.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Brandon, I read your answers. Based on your answers, you meet the eligibility requirement for the court-appointed attorney. The attorney that will be appointed to represent you is Attorney Laurie Perazzo. Attorney Perazzo will be given information to contact you, and you will also be given information to contact her. The court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall.
Yes, sir.
Okay, thank you.
It was yesterday.
Best lady is go ahead and let me take a phone. Good morning. Yeah, going down.
So, Lord. Okay, we need Savoy. Devontae Savoy. $21.
Or never.
And this is court is in session in two cases, cause numbers 26CCCR 0820 and cause number 26CCCR 0821. Both cases are styled the state of Texas versus Devontae Savoy. Mr. Savoy, is that your full name?
Sir.
Mr. Savoy, would you please raise your right hand? Savoy, did you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Savoy, you may put your hand down. How are you doing, Mr. Savoy?
You're doing great.
You're doing great. That's good. Now, Mr. Savoy, you're represented by your attorney, Attorney Langston Adams. And Mr. Adams, how are you doing?
Doing well, can't
And
complain.
Mr. Adams, do you waive a record in Mr. Savoy's case?
Yes, sir.
And the state is represented in this case by Attorney Cornelius Williams. Mr. Williams, how are you doing?
Very well, thank you, Your Honor.
And Mr. Savoy, I have before me a document in clause number 26CCCR 0821. This document is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Devontae Savoy, on or about February 26th of 2026, while you're in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft of property that had a value greater than or equal to $100 but less than $750. Mr. Savoy, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Savoy, how did you plead? Guilty, not guilty, no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily? Now, Mr. Savoy, I have before me a document. The document says that you pleaded no contest. Are you pleading no contest or are you pleading guilty?
Please, come on, no, please, no, I don't get it. No, that's what you said. Yeah,
Now, are you pleading no contest freely and voluntarily?
Yeah.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Savoy, I also have before me a document that is titled Misdemeanor Plea Admonishment, which is also labeled as State's Exhibit Number 1. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on the line next to a box that says check nola contendere, which means no contest. You place your initials on this document.
Sir.
On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature? And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
I also have another document on paper that is titled discovery certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Mr. Boyd, before you signed and initialed all of these documents, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Savoy, are you a citizen of the United States?
Yes, sir.
State,
State Kansas City Honorable Court, State's Exhibit Number 1.
any objections?
No objection.
No objections. State's exhibit number 1 will be admitted. Mr. Adams, you advised and counseled Mr. Savoy. Is there any evidence that he is currently mentally incompetent to stand trial?
No evidence that has been accomplished.
And Mr. Savoy, your attorney, Mr. Adams, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Mr. Savoy, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I'll also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
It would be 95 days in the Jefferson County Jail, credit for
Was it 94? Or was it 95?
94, it's fine, 94 days, in Jefferson County Jail. Credit for time served in consideration of the plea. The state will dismiss 26 CCCR 0820, which is a companion case. Is that correct, Mr. Al?
Yes, sir.
Okay. Okay, Mr. Savoy, the state is offering that you serve 94 days in Jefferson County Jail. You will not have to serve any more time in Jefferson County Jail in this case because you've already served 94 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. Court costs in this case will be taxed and retired. That simply means that you will not have to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. And cause number 266 CCR 0820, the companion case will be dismissed as part of the plea bargain in this case. Mr. Savoy, do you understand the state's offer?
Yes, sir.
You think the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Savoy, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Savoy, you stand next to the bailiff, follow her direction. Once you finish following her directions, you can follow the bailiff, and you have a blessed day.
Thank you, Judge. Appreciate you.
All right, thank you.
Yeah, that day.
Is that Lamonte Cunningham?
Oh, okay.
Is what? Lamote? Okay. Okay, Mr. Cunningham, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Cunningham, you may put your hand down. How are you doing, Mr. Cunningham? I'm doing fine, thanks for asking. Mr. Cunningham, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? Or are these your initials on the line that state you would like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indians. You recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant's Signature. Is this your signature? Mr. Cunningham, before you sign and initial these documents, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Cunningham, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that would be appointed to represent you in your case is Attorney Marva Provo. Attorney Provo will be given information to contact you. And you will also be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. And you have a blessed day. Please have a seat in that second chair on the wall. Well. Is that no Ishmael Makata Carino?
You can get a call.
Okay, Mr. Carino, your full name is that
No,
Noe Ishmael Makata Carino?
yes, sir.
Would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. Now, before we go any further, Mr. Makata Carino, I see that you, I need to get some information from you. This document that is titled Judge's Explanation of Rights to Defendants Without Attorney, you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled, Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that's titled Defendant. Is this your signature?
Yes, sir.
Is everything on this document true and correct to the best of your knowledge?
Yes, sir.
Okay. Mr. Makata Carino, I need to ask you some questions and turn this on. Okay, is everything on this document true and correct to the best of your knowledge?
Yes, sir.
Let me do this here. This is 6, this is 6.
It's a plea.
Right. Yeah.
Okay, Mr. Mercado Carino, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
Thank you. You too.
All right, stand in front of the coordinator. Jefferson Bonilla? Or Bonilla? Oh, okay.
Yeah.
Okay, just have me have a seat, you can call Jennifer. Okay, this is cause number 26 CCCR 0798. Case is styled the state of Texas versus Stacy Gail Freeman. Ms. Freeman, is that your full name? Ms. Freeman, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Freeman, you may put your hand down. How are you doing, Ms. Freeman? That's good. Now, Ms. Freeman, before we get started, you have a right to have a record made of this proceeding by a court reporter. You also have a right to waive, which means to give up your right to have a record. Do you waive or give up your right to have a record?
Sure, I'll wait.
Okay, Ms. Freeman. I have before me on my computer a document. Well, before I get to that, I have before me a document on paper that is titled Judge's Explanation of Rights to Finish Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant?
Mhm.
Or are these your initials on the line that state you like to waive your right to an attorney to represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding in Trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant? I also have another document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Stacy Gail Freeman, on or about January 18th, 2025, while you were in Jefferson County, Texas, that while you were operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of driving while intoxicated. Second, and this information further alleges that prior to the presentment of this information, that on July 21st of 2022, in cause number C113043 in County Court at Law of Orange County, Texas, that you was convicted of an offense relating to the operating of a motor vehicle while intoxicated. Ms. Freeman, do you understand what you've been charged with?
Yes.
Well, before I do that now, this paragraph, is it true that you were convicted in Orange County, July 21st, 2022, in cause number C113043 in County Court at Law, Orange County, for an offense relating to the operating of a motor vehicle while intoxicated? Is that true?
Yes.
And to the offense of driving while intoxicated. Second, how do you plead? Guilty, not guilty, no contest? Now, you're pleading guilty freely and voluntarily? And are you pleading guilty because you're guilty?
Well, I do believe I was roofied a little bit, but yeah, I had drinks. Yes, sir.
Okay, so you're pleading guilty because you're guilty?
Yes, yes, sir. I'm done.
Okay. Now, Ms. Freeman, I also have before me a document that is titled Misdemeanor Plea Admonishment, is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of the same document, back up. I get checked the wrong box. It's supposed to be,
Did I check the wrong box?
yeah, it's supposed to be DWI's second box.
I checked the wrong box, let's see.
Should be the fourth box. Hmm? What it does, it changes the range of punishment to a minimum of 30 days to a maximum of 365. Okay, now, Ms. Freeman, there's one box that's checked on this document on page 1, states that this is a Class A misdemeanor and the range of punishment, minimum confinement 30 days in the Jefferson County Jail to a maximum of 365 days. You could be given a fine that does not exceed $4,000. Do you understand this?
Yes, sir.
Okay, on page 2 of this same document, there's 2 sets of initials. First set of initials is next to the box that's checked guilty. Did you place your initials at
Yes.
the top? At the bottom, the second set of initials is next to a sentence that states, I do not request discovery. I waive my right to discover in this case and choose to enter or plead guilty, no contest. You place your initials in the second location as well. On page 3 of this same document, there are a set of initials, excuse me, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
On the next document that's titled trial court certification, the defendant's right of appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Ms. Freeman, before you signed and initial all the documents that I showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Ms. Freeman, are you a citizen of the United States?
Yes.
The state offers State's Exhibit number 1, Judge.
Ms. Freeman, the state is offering State's Exhibit number 1 to be used as evidence against your State's Exhibit number 1 is the first document that I showed you on this tablet, document that has the box checked on page 1, that's saying that this is DWI second. It also has your initials in these 2 locations on page 2, and on page 3, it has your signature. Is it all right for the state to use this document as evidence in your case? No objection. State's Exhibit number 1 will be admitted. Ms. Freeman, is there any evidence that you are currently mentally incompetent to stand trial?
Yes.
Ms. Freeman, I will accept your plea of your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is where does that keep blanking? I also will find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Judge.
And what's the agreement?
It would be 270 days probated over an 18-month period of time. There would be a $200 fine, 40 hours of community service. In the JCDI program, eliminate devastating conditions for a DWI second. And then Ms. Freeman will surrender on Thursday, June the 4th by 6 p.m. to serve her 72 hours.
Oh, but that's it. I have no June 6th.
Then I June 4th?
I think you did right, June 6th.
No, it's June 6th.
I don't know why I wrote June 6th.
That'd be fine.
What's the day?
June 6th is a big Saturday.
Yeah,
You don't want
yeah.
Morning Friday.
Yes, yes, sir.
Can we do the 5th?
Yeah,
Let's just do the 5th is fine. That would be
we don't take
fine.
them.
I don't know why I wrote June 6th.
So it's June the 5th?
Yes, sir.
Okay.
Friday.
Which one?
Thank you. Is that correct, Ms. Freeman?
Now, she has,
That we talked about?
yeah, but I think you gotta put the, I know JCI, yeah, you have to check off the box for interlock.
I
It's
thought
DWI second.
it's right there, Judge.
What?
Right,
Oh,
right
okay.
the day she surrendered.
But I don't think you said it though. Okay. Okay, interlock. Signature, and that'll be the, intervention. Okay, let me see, DWI, JCDI.
6 and 5.
That's 270 over 18 months. 200. Those court calls. It's 40 hours. What's the court calls?
392.
Two.
This is going to have to be. Between all your fees, you find out. Take it down. So you have.
Okay, Miss Freeman. State is offering that you serve 270 days in Jefferson County Jail. However, you will not be required to serve 270 days in Jefferson County Jail because it will be probated for a period of 18 months. During the 18-month probationary period, you'll be required to pay a fine of $200 plus court costs of $392. You'll be required to pay a DWI conviction fine fee of $100. You'll be required to pay a probation fee of $60 a month. Your analysis fee of $15 a month, reimbursement fee of $15. You'll also be required to pay Jefferson County DWI intervention fee in this case. Now, your total monthly installments, the total monthly installments in this case is $121 a month. Will you be able to pay the $121 a month?
I can manage that, yeah.
Okay. You'll also be required to install, you'll be required to perform 40 hours of community service. You'll be required to install the interlock device on any vehicle that you own or operate, attend and complete the DW education class, attend and complete the Jefferson County JCDI program. You're required to serve 72 hours in Jefferson County Jail beginning on June 5th. 2026 at or before 6 p.m. And you will also be required to adhere to the other standard terms and conditions of this DWI's second probation. Now, Ms. Freeman, do you understand the state's offer?
Yes, sir.
You think the state's offer in your case is fair and just? Do you accept the state's offer? Ms. Freeman, I'll follow the plea bargaining agreement that you have entered into with the state. Ms. Freeman, you'll stand at the end of that table, have a seat. Just have a seat in that first chair and wait for your name to be called. Once your name is called, you'll follow the directions of the bailiff. Once you finish following the directions, you'll be free to go and you have a blessed day.
Thank you, sir.
Good
You're
luck.
welcome. Is that? Who else we have? What's this person's name?
Ashley, Stanley.
Oh, Ashley Stanley?
Put your stuff right there on the table.
Good day, Ms. Stanley.
Miss Stanley. Your full name is Ashley N. Stanley? Miss Stanley? Would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God. Miss Stanley, you may put your hand down. How are you doing, Miss Stanley? Okay, I'm sure you've been worse too, huh?
Radiation's not so good.
Okay, well,
But,
we'll pray that you feel a lot better once you leave here.
yes, sir, thank you.
Okay. And Ms. Stanley, I have before me on my before we do that, I have before me on paper two documents. The first document is titled Judge's Explanation of Rights to Defendants without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled?
Yes, sir.
Uh-oh, our signature is not on there.
Oh.
So we, and is that your signature on the line that's titled defendant? And are these your initials on the line that state that you would like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled waiver of counsel for purposes of enter a guilty plea or proceeding trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Ms. Stanley, I also have before me on my computer a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you actually in Stanley, on or about March 5th of 2026, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft of property that had a value greater than or equal to $100, but less than $750. Ms. Stanley, do you understand what you've been charged with? And to this charge, Ms. Stanley, how do you plead? Guilty, not guilty, in the contest? Yeah, no contest? And are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Stanley, I also have before me a document that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, there's a set of initials, AS. There are two sets of initials. First set of initials are on the line next to boxes check note contingent, which means no contest. Did you place your initials on this document?
Yes, sir.
Second set of initials are below, well, they're on a line next to a statement that reads, I do not request discovery in this case. I waive my right to request discovery and choose to enter a plea of guilty or no contest. Did you place your initials in the second location on this document? And on page 3, there's a signature above the line that's titled defendant. Is this your signature? And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
defendant?
sir.
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargaining case and you have no right of appeal. Do you understand the statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Ms. Stanley, before you signed and initialed all of these documents, did you read the documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Ms. Stanley, are you a citizen of the United States?
Yes, sir.
State offers State's Exhibit Number 1, Your Honor.
Ms. Stanley, the state is offering State's Exhibit Number 1 to be used as evidence against you. State's Exhibit Number 1 is the first document that I showed you on this tablet. It is the same document that has your signature on page 2 in these two locations, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? Ms. Stanley, State's Exhibit Number 1 will be admitted. Ms. Stanley, is there any evidence to suggest that you're mentally incompetent to stand trial? Okay, Ms. Stanley, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargaining agreement?
We do, Your Honor.
And what is the agreement?
It'll be 1 day time served, Judge.
Okay, give me the
That's correct.
courthouse. See if she has a affidavit of injuries.
You in
Steve.
jail for 2 days?
277.
Okay, she said she went in jail for 2 days.
Before, and the next day I didn't get out until like that evening later.
Okay,
I would consider 2.
yeah, if you was in jail 2 days, it's 2 days. The problem is, she might have been in jail, they may not book her in until after 12, you know, that's,
That's.
hopefully they didn't do that, but.
Like they did. the electricity was messed up that day and there was all kinds of stuff going on in the jail, so.
Hmm,
It's just.
she has an affidavit.
It's nuts, it's. Okay, you see.
Oh, yeah, there's some things can be done, it's not. Let's see, there's some Stanley. Okay, now, what's your, court cost?
277.
277. That's 1 day. 1 day. Great. Now, Ms. Stanley. The state is offering that you serve 1 day in the Judge County Jail. You have credit for the 1 day that you've already served. Court cost in this case is $277. You have 1 day credit that goes toward that. It leaves a balance of $177. Are you able to pay the $177? Okay, Miss Mosby, could you give her just that first form of the affidavit? You have one? Oh, she said she already had one.
Yeah, I told her.
Oh, okay.
I want to get first, girl.
It's right there on top.
Oh, right here. Mhm.
Did you finish? Did you fill it out?
Yeah.
Okay. She's okay.
I don't know if it says together or whatever, I'm sorry.
Okay, thank you. Okay, Ms. Stanley, I have before me a document that is titled Jefferson County Affidavit of Indigence. You recognize this document? Is everything on this document true and correct to the best of your knowledge?
Yes, sir.
Ms. Stanley, I'm going to find that you are indigent. And that simply means that you will not be required to pay the balance of $177 pursuant to Article 42.15 of the Texas Code of Criminal Procedure. Now, Ms. Stanley, do you understand the state's offer? Do you think the state's offer in your case is fair and just? And do you accept the state's offer? Ms. Stanley, I'll follow the plea bargaining agreement that you have entered into with the state with the finding that you are indigent. And Ms. Stanley, this will conclude your case. You can stand next to the bailiff. And once you finish with the bailiff, you'll be free to go. And Ms. Stanley will be praying that you have a full and speedy recovery. Okay, you have a blessed day.
You never see that.
Okay, we have, is that Boone? That's you, Mr. Boone? Okay, would you come on up, Mr. Boone? How you doing, Mr. Boone? I'm doing all right. Now, Mr. Boone, I have two documents before me. This document, first document, the judge's explanation of rights to defendants without attorney. You recognize this document? I mean, a waiver of, yeah, judge's explanation of defense without attorney. And is this your signature on the line that's titled defendant?
Yes, sir.
Are these your initials on the line that state you like to waive your right to attorney and represent yourself?
Yes, sir.
I also have another document that is titled waiver of counsel for purposes of entering guilty plea or proceeding to trial. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Now, before you sign and initial these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Now, Mr. Boone, then you and the state have talked, and
Yes, sir.
Mr. Williams?
We have, Your Honor. It has a felony case 26D CCR 0732, which arose out the same set
Boom.
of facts. Yes, sir, Judge.
He has a felony where?
Yes, sir. And it's set for July 13th.
Okay, so Mr. Boone, this case will be reset with your felony case for July 13th. You'll be given your reset information from our court administrator. Once you get that reset, you're free to go and you have a blessed day.
Mhm.
That's what Marcia Norman is on the felony.
Okay. Can you send you what?
Then,
Okay. Okay, let me do this here.
Oh, bring it,
Court of,
baby.
yeah, hold on. Court will be in recess until 1:30 for